these cases, the court must allocate parenting time based on the best interest of the child and the factors outlined in 1410-124. I'm just going to go through a couple of those that I feel the evidence presented would be most relevant to the court. The first factor is the parent's wishes. Mother has proposed a parenting plan that is Exhibit 1. Mother has proposed a graduated parenting time schedule and testified that she did so in order that she can develop her relationship with the children over time and with the help of a parenting coach and support. Mother has not come in here and demanded overnight to begin immediately. Mother has testified that she recognizes that her relationship needs to grow. Mother testified that she wants the children to be comfortable in their surroundings and proposed for the first visit that they be at a place that they're familiar with, which is Father's apartment complex. Mother is proposing a parenting coach be there for the first couple phases so that she can get help in developing her relationship. Mother was not there at the children's birth. She did not have the option to learn how to develop that relationship. Mother testified that she believes that frequent and consistent time with both parents is in the children's best interest. And without time to do so, it will never happen. Mother's graduated parenting plan is in the children's best interest. On the other hand, Father has proposed no parenting time plan at all. In fact, he testified that he wants without Mother's consent or a court order. In re Marriage of Martin, which is 42 P. 3rd 75, provides that a reasonable parenting time plan is mandated and undue restrictions on parenting time are prohibited unless a party can prove endangerment. Father has not met that burden. Father testified that he has concerns related to Mother's mental health and gave examples of alleged instances that occurred in 2018 and 2019. These instances occurred prior to the parties even engaging with the surrogacy agency. This begs the question, why would Father commit to bring children into the world with somebody he feels like is mentally unfit? Additionally, he had the ability to, but failed to do psychological evaluation or parental responsibilities evaluation if this was a legitimate concern. Father has not demonstrated that he has the ability to encourage the relationship with Mother and the children. When asked directly, he couldn't answer the question. The evidence presented today and on March 22nd demonstrated that Father was attempting to build a case against Mother even before the children were born. Mother testified that Father was communicating with the agencies by himself without her knowledge. Father began communicating with the surrogates alone in 2019 after the parties' relationship ended. Only days after the baby's birth, Father requested each surrogate make a video for him because his attorney thought it would be a good idea. Even though Father was at the birth, Father sent no pictures, did not share the baby's names, never shared the children's first words, or provided any updates at all. Father sent one message to Mother, and that was in January, and he knew she never received that message. While Mother also admitted she did not reach out, Father failed to reach out as well. Mother acknowledged and admitted that she was delayed in seeking out information regarding the children. And when she did in February of 2020, through the agency, the surrogacy agency, there was testimony that Father was invited to that group, and he withdrew from that group with Mother. At that point in time, he could have communicated with Mother regarding the children when she asked. When Mother did come to Colorado in February 2021, Mother didn't have parenting time for nearly a month. And Father testified that he insisted on supervising her parenting time, even though Mother offered and paid for a parenting time supervisor to be present. Father couldn't articulate any positive traits for Mother. And when asked how much time is appropriate or in the children's best interest, Father couldn't answer the question. Father's actions since birth have put in question whether or not he can put the children's needs above his own. Father posted multiple times on the Chinese social media platform Weibo regarding the children, and those are exhibits 8 and 9 to the translation, without regard about how that publicity will impact the children. In allocating the decision-making responsibilities, the court must look at the factors in 1410-124. Mother is proposing the parties share decision-making responsibilities for all major decisions regarding the children. Mother testified that she hopes and believes that these parties can move past their conflict and make decisions together for their children. Both parties were able to make joint decisions regarding the children. Mother testified regarding the surrogacy process. Father testified that they chose together to have 2 children in the year of the pig. At one point in time, these parties were making joint decisions. Father testified that he does not think Mother deserves to be a part of any major decision for the children. If the court allows Father to have sole decision-making, Father has demonstrated no ability to be able to support Mother's involvement with the children. Mother is also requesting an order that a third party hold on to the children's passports. Mother testified that she would consent to obtain passports for the children. And Father never provided any of the passport applications for her to sign, or it never requested anything through the court for Mother to be compelled to sign for the passport. In Father's trial position statement and also in his testimony, Father says he should be able to move wherever he pleases. And the court should allow that based on Palmer and Avery American 428 P. 3rd 550. The facts of the Morgan case contrast starkly with the facts of this case. In Morgan and Palmer, the party that was intending to move was unequivocal where they were going multiple times through the case. In Morgan, the wife asserted over 5 times through the proceedings that she was going to live in California. Here, Father has not asserted where he will be living. He first testified that if his visa gets denied, he goes back to China, he'll come back to the United States. Where in China? Where else will Father go? It would be inappropriate for the court to allow Father to travel or live wherever he wants to live under Morgan and this Palmer analysis. Father's case focused on the past, including Mother's contemplation of adoption and abortion, which she fully admitted and acknowledged. And she said she contemplated these options because she was scared. Mother's not like many other women out there who are pregnant and are contemplating their options. If she is now to be judged for those questions, how would that communicate to the public policy considerations? Mother testified she ultimately changed her mind and she testified that she is committed now to being their mother. Mother is here now in Colorado. Mother is requesting parenting time with children. Mother wants the opportunity to develop her relationship. Mother is focused on moving forward in the children's best interest and proposed a graduated parenting time to allow that to happen. Father has focused on the past. Could not say one positive thing about Mother, only that she lies and that she considered adoption and abortion. The concern is whether Father will be able to let go of his anger and support Mother's relationship with the children. At this point in time, there's no record that he has the ability to do so. That's all I have, Your Honor.
Thank you. Thank you. Whenever you're ready, Ms. Hogan. Sure.
Ready?
Case presents a study in contrast. Mother advocated aborting the children when that wouldn't work. She suggested abandoning them at the hospital. She pressed for adoption. She didn't show up at the birth of either child. She claimed to be unaware of when or where they were born, notwithstanding that she had equal access to the agencies who had arranged the surrogacies and to the gestational carriers who were sacrificing their own lives and families to carry the pregnancies that Mother chose not to carry. She, in fact, waited until the children were approximately 15 months old, and she had public relations problems in China before she made any effort to even meet them. It was interesting in her testimony on the 22nd, we heard about her staff of who depend on her. We didn't hear about the two helpless children who she had left to fend for themselves, and that's exactly the position they would have been in if Father hadn't stepped in and been there from birth for each of them. Yet in the petition for allocation of parental responsibilities, Mother claims she should be the sole decision maker. She should decide where they live. This isn't a position or a person who appears to be in touch with the reality of raising children. The contrast in the presentations is similar. Mother shows us pictures of car seats and high chairs, but she doesn't know anything about the children's medical care or their routines or even if they can talk. She doesn't appear to know anything about the developmental needs of toddlers or strategies for dealing with toddlers. And so when children who have been strangers to her have trouble adapting to her, she suggests that Father is somehow interfering visits instead of acknowledging that when you meet a child at 15 months as an absolute stranger, things aren't going to be smooth at the beginning. Mother admitted to having an unstable personality. She sent concerning photos that support that concern. We've got the haircut. This is her way of apologizing. We've got the texts that say she can't find her way. She can't take care of herself. At best, this would be behavior that is impulsive and perhaps attention-seeking, but not necessarily the behavior of someone who is ready to be a parent, at least a parent without a support system of other people who are actually going to take care of the children. By contrast, Father put his entire life on hold. He made arrangements to be present at the birth of each child, notwithstanding that they were being born in